So the last time we had Lauren Taylor on our show, as we were anticipating this big status conference in Alec Murdaugh's bid for a new trial, we were operating really in a vacuum, an atmosphere of uncertainty. We didn't really know which way this hearing could go. Obviously, we had thoughts from both sides. It could go for the state, could go for the defense, but we really didn't have any sense at that time of where this case was moving. But Lauren Taylor, as you join us on the day after this big status conference in this case, we've got a sense of where this case is going now, don't we?
We do. I think a lot of people were surprised yesterday, but it's definitely laid the foundation for a clear outcome, at least for the state.
Well, let me ask you this. As you were watching the hearing yesterday, and I know you've also been reviewing it in particular parts of it, were you surprised by how aggressive former Justice Jean Toll was, and how one-sided she was in her decisions yesterday?
Well, I think that, first of all, Justice Toll is widely regarded as one of the most well respected jurists in our state. And that's why she was handpicked by Justice Beatty to cover this. So she's not up for reelection. She has no political ties here. So the hope and the assumption is that she is going to be able to rule on this in a way that is going to help get us back on track as far as our justice system and the way we look to not just the state, but the rest of the world at this point. I was a little bit shocked because I thought that the defense had some really good arguments. Now, the case law that Justice Toll outlined, a lot of these cases are really confusing because they cite each other and they make differential arguments in the dissent sometimes as to why one justice might be inclined to rule a different way if certain facts were different. So that is really all we have at this point as far as trying to get a read on how these justices, are going to rule on this once it reaches the appellate level. But yesterday, I would definitely say was a huge win for the state, and Justice Toll really laid some pretty strict parameters on how she is going to conduct this evidentiary hearing, which she made note to everyone that it is not a Reamer hearing; it is just an evidentiary hearing. So it's going to be interesting to see if the defense can get anything back on their side during that 3-day hearing. So I think that's what we're all kind of looking for at this point.
Well, let's talk about some of the standards that are in play in these cases. And a credit to you, all of the cases that you talked about the last time we spoke were discussed as it related to the standard that Justice Toll is going to apply here. Obviously, she has chosen State v. Green. Walk us a little bit through that case, Lauren, and what that means for the bar that Alec Murdaugh's attorneys now have to meet.
So State v. Green is the case where the bailiff was the one that was the court official that allegedly had communication with a juror. And I believe the context of that communication was what would happen if the jury was deadlocked. The jury was never deadlocked in that case. And the bailiff's answer was what the court deemed to be procedural and basically saying, hey, if you don't get a verdict, the judge is going to instruct you to stay later and might issue an Allen charge. So in that case, in Green, that was the issue at hand. Now, Green also references Reamer, which is what the defense was really heavily relying on. In Reamer, I believe, and correct me if I'm wrong, but I believe that was a case where the allegation was that a private party offered to pay a juror if their verdict was influenced. And that is the case where the analysis prong comes out to where we have to walk through, was that contact harmless by that court official? So what Justice Toll is essentially doing in this ruling is saying, we're not going through the harmless analysis here. It doesn't even have to get to that. We're going to ask the jurors directly what was said to them, what they heard, and what effect that had, if any, on their verdict. So the entire 4-prong analysis of what is harmless and what isn't is taken out of the equation, at least at this point.
I wanted to ask you this, though. You raised the point about harmless contact. One of the things I found interesting about Justice Toll's reliance on this Green ruling, which, by the way, you absolutely nailed the recap of that. But if you look in that ruling, there is a reference that distinguishes the bailiff's contact with the jury in that case as a procedural matter, and arguing it did not go to the merits of the case. Well, the defense is arguing on Mr. Murdaugh's behalf that the contact that Becky Hill allegedly had with jurors very much went to the merits of the case. And so I'm curious, the Green case does seem to imply that type of contact is important. And could that potentially help the defense?
So here's what I think is important to differentiate. So what in that footnote that you're reading, which I believe is Justice Beatty's writing, where he talks about that there does not need to be a Reamer standard in every situation, okay? And that is kind of what I'm seeing Justice Toll really, I think that's what's floating around in her brain, because as with the bailiff and as with the clerk of court, and I think you heard both the state and the defense yesterday talk about how they had thousands of emails from Becky Hill, well, both sides. That is her job as the clerk of court, is to communicate with jurors, with SLED agents, with witnesses, with defense and prosecution counsel. So by every nature, her communications are going to be, affecting something. It's just whether the contact is harmless or not. So I think there's a real focus here on trying not to, curtail the justice system by saying every time we have a clerk that speaks to a juror, we now have to have a Reamer hearing. I think that is what the clerk or Justice Toll is afraid of setting a standard up, because a lot of things, a lot of contact is going to be made, and it's not going to rise to a standard where we have to have a full hearing on it. Now, whether it's harmless or not, I think is what we're going to have to get to. The harmless part is taken out of this, but whether it actually goes to the bias is what Judge Toll is going to focus on here. And I believe there's only one juror that indicated in their affidavit that their information or the information that was shared with them from the clerk of court impacted their verdict in one way or another. The bigger issue here that I think is relevant, and if I was Dick, I would have been screaming from the rooftops when Justice Toll got to the third prong, which was, I believe, the witnesses and what order they were going to be called in. The fact that she made the ruling to only question the witnesses that sat in jury deliberation. One of the state's main arguments is that Becky Hill's motive to do anything that she did in relation to tampering with this jury was for her to get a guilty verdict, because a guilty verdict would in turn result in higher book sales. If you're following that mode of thinking, and that was her motive, which Justice Toll quickly, I think she said, do not bring that up again. If I hear you say that again,
she shot him down.
She shot him down. But if you're following that mode of thinking, that juror that claimed that she had contact with Ms. Hill, the Facebook thing was brought up, she, was eventually excused. Now, the judge did say it wasn't for the Facebook post, but my argument would be that the juror that was excused that would have participated in that deliberation, she could have very possibly rendered a not guilty verdict or put her vote in for not guilty, which would have resulted in a hung jury. Or maybe she would have been able to convince another juror to join her. What is happening in that jury room and how often they communicate and talk about the case is not going to be discussed here. Judge Toll was really clear about that. She doesn't want any kind of nitpicking about who said what to who and who was a part of this conversation with the forewoman and who wasn't. It's really only going to be what was said and how did you process that in terms of rendering your verdict.
Absolutely. And I love, by the way that you point out how this is not only a matter for the Murdaugh case, but that Justice Toll also has to consider all the cases that are going to come after this as she makes this determination. So I really love that. But I did want to, going back to your point of what was said and what was its impact, I wanted to pull this tweet up, and I'm going to read it to you just so we can have the audience hear it. But it relates to that very specific matter. And it talks about this juror, number 630, who, again, according to this, Ms. Billups on Twitter, she's great. By the way, I'm following her. If you're not yet, check her out. But she speaks about how the juror stated very clearly in their affidavit that Becky Hill not only spoke to jurors, but that it influenced their verdict. Becky Hill has claimed that never happened. And so it's ultimately going to be down to Justice Toll, assuming this is what she hears and what we hear in the testimony, assuming that happens. Let me ask you this, Lauren. Chief Justice Toll has set a very narrow standard for this inquiry. She has set a very narrow scope of questioning for the folks who are coming in, and she has very severely tailored the list of people who are going to come in to talk. If one of those jurors, as we believe will happen, says that Becky Hill influenced their verdict and Becky Hill denies it, where does Justice Toll go from there, having set these standards herself?
I think she's painted quite the box. I think her denying the jurors' attorney's request to have them questioned in camera is her way of saying, I want this to be fully out in the open. I want everyone to be able to hear me ask these jurors these questions, what their answer is, if there's any follow-up that needs to be, asked from the state or the defense. I think that is her cure for some other rulings that the defense might not have liked, is that we're going to give you this, you're going to get to do it in open court. Now, if any of the jurors differ in their testimony from what they submitted in those affidavits, that's going to create some issues that could possibly lead to a perjury charge. I in no way anticipate that happening, especially because most of these jurors are represented by counsel, and I'm sure they've been made aware, that what the contents of their affidavit are. Now, Judge Toll did bring up, she wants both the state and the defense to offer proffer evidence on any witnesses that she deemed not worthy to be called at this point, but she's reserving the right that they might be called based on any evidence that could be proffered at the time.
Walk us through that, Lauren. Tell us a little bit. What does that mean, a proffering evidence? What was Justice Toll referring to there?
So a proffer is essentially when you're handing up evidence to a court that you want them to take into consideration when they're making a ruling. It doesn't necessarily have to be a witness being cross-examined. Now, what Dick and Jim are arguing is that if we proffer up an affidavit, we're taking away the right to, the confrontation clause from the state to be able to cross-examine that witness and poke whatever holes or impeach them for any purpose. So they're kind of using the state's argument against them right there. But I think that is going to be the difference there, is what those jurors say. And, Ms. Hill can say all day long, I didn't say that. I don't know that the saying it is going to be as important as the juror's interpretation of it. She could have said, it's raining outside. And if a juror interpreted that as, I need to vote Alec Murdaugh guilty in whatever way, that is going to be the crux of the case, is what, because it really depends. If she says, I think he murdered his family and here's why, it still has to resonate with that juror and come to their bias level to where they would actually change their verdict because of that information.
Let's talk a little bit about Clerk Hill now, obviously addressing the juror testimony, but let's look now at her potential testimony. Her attorney, Will Lewis, was in the court yesterday, and it was interesting. He spoke very briefly when Justice Toll invited him up to the stand, to the podium, but he did say that he would make her available and also volunteered to accept service on a subpoena. Now, we spoke at length the last time we talked about whether or not Becky Hill would invoke the Fifth Amendment in response to questions that may be posed to her by Justice Toll. Where are you now on Becky Hill standing? Do we think she's going to assert the Fifth at this point?
I don't think she's going to have to. I think Justice Toll was pretty clear in what questions she's going to be allowed to be asked of Ms. Hill. A lot of the things that have come out in the last few months as far as her credibility in her office and things that she might have been doing that, violate the ethical obligation she has, unfortunately, are not going to be relevant. Justice Toll was really clear that she is only interested in the actions that Becky Hill took during the course of the 6-week trial. So that's going to be the crux of the issue here. And she's also been really clear with the attorneys that she has no interest in them admitting 1,000 exhibits of emails. They're going to have to be really clear and concise with what they want Judge Toll to see about Becky Hill and what evidence they have that really goes to the crux of the issue. I think overwhelming her with massive amounts of document dumps to say, look how many times she's acted inappropriately is going to, it's going to aggravate her. She wants to say, what exactly did she do? Point to it. Let me see it. If you have it in a document and an email, that's more irrefutable than, a person's testimony. So that's what she wants. She wants it very tailored. So I think Becky Hill kind of, is thanking her lucky stars that she's not going to be opening a door to unlimited questions that could lead to later criminal prosecution. So I would be shocked if she evoked any Fifth Amendment right. I think her attorney was very happy with how the judge ruled as far as what the parameters are going to be placed on her. And as far as issuing a subpoena and him accepting service, that was polite, but the alternative would be for them to go physically get her and drag her into court. So there's not really a lot of points gained for Ms. Hill by offering that. we'll see.
Well, you're right. Attorney Lewis for Clark Hill looked absolutely ecstatic during that hearing, matched perhaps only by Creighton Waters for the state. And of course, I mentioned as we were doing our live broadcast, seeing the Attorney General walk through the courtroom, giving a look to the press pool, indicative of his pleasure with how the proceedings unfolded yesterday. Let's bottom line this, Lauren. We talked last time about where we think this is going in terms of a decision from Justice Toll. I had been very solidly in the camp that Murdaugh, the needle was tilting toward him getting a new trial. After yesterday's hearing, I think that is tilted back the other way. Where are you on his prospects at this point?
I would agree with you. I think before the hearing yesterday, I was really moved by the defense's briefs. I think their arguments were creative, and I think it was undeniable to read some of the assertions and not automatically go, well, of course this wasn't harmless contact. But with Justice Toll, changing the standard of proof and saying, I'm going to make this the defendant's burden, I think that has kind of reframed things. And, absent any shocking information that comes forward in those 3 days, I think it is looking like it's the state's to lose at this point. Now, this is all appealable as well. Whether the appellate court, is going to have 3 justices that are going to be looking at all of the other issues that Mr. Murdaugh has filed an appeal on. They have discretion on if they want to move this case up to the top of the docket and go ahead and say, let's address all of these issues now so that we can quite literally put this case to rest for the state of South Carolina, or they can say, okay, we're going to, lump this in and we'll get to it in the proper order when we have gone through other cases. We've got COVID backlogs and all of that too. So the docket is definitely full. But Justice Toll is the one that has been handpicked for this because her opinion is so well respected, and she is going to be meticulous in questioning these judges, reviewing these affidavits. So if I was Dick and Jim, I would be getting every additional detail I possibly could into these affidavits so that you can proffer it and offer it to her in the hopes that she would then decide that witness, particularly the one that was excused, is worthy of being called to be examined or cross-examined by the defense.
Yeah, and obviously they severely limited the ability of the defense to impeach anything that Becky Hill says regarding the jury tampering allegations, literally shut that down. As you mentioned, Lauren, you're incredibly gracious with your time and your wisdom. I got to ask you one more question, though. As we look at this moving forward, you made a great point a moment ago about how this decision is appealable. Let's assume that the appellate court, the Supreme Court may take it in original jurisdiction and just rule on it. Let's assume the highest court in South Carolina upholds a decision to deny Alec Murdaugh a new trial. Does he have a federal case on Sixth Amendment grounds that he could then make?
Yes, possibly. And that's what Dick and Jim are being so careful about. You heard a lot of mention yesterday from both sides, but both the attorneys as well as the judge on preserving this record for appeal. So I think that's what everyone's thinking. And I'm sure Dick and Jim are already planning what their strategy is going to be if they're not successful at the end of the 3-day evidentiary hearing. So this is not over. The portion that has to deal with juror misconduct might be over at the end of the evidentiary hearing, but the issues that are preserved, and quite honestly, I fully expect Dick and Jim to appeal the decision on not granting a new trial if that is in fact what Judge Toll does. So we won't be seeing the end of Dick and Jim or Alex Murdaugh anytime soon, unfortunately, but it will be interesting to see how it plays out and what our state is able to navigate. I think a lot of people would love to see this start fresh just because of all of the issues with tampering. And I think Justice Toll, while she is putting these parameters in place, it's also to keep the office and the integrity of the office in place. It doesn't look good for the state of South Carolina to put Becky Hill up there and to, go through every email she sent that was inappropriate during her capacity as the clerk of court. It doesn't make anyone look good. So I think that is another thing that she's cautious of, is how is all of this being presented to the public and how open is she being about it and how clear is it how things are going to be done and what's acceptable and what's not acceptable. I'm sure the clerk of court that was there yesterday was paying attention to every single thing, probably saying, I hope I don't say anything that could be deemed harmless or meaningless, because I'm not wanting to put myself in this situation.
Well, Lauren, I actually lied. I've got one more question for you. I wanted to ask you this. You spoke the last time we were together very eloquently about what justice demands in this situation. You just mentioned the integrity of this system of justice here in South Carolina that has been so maligned in recent years, and rightfully so. But let me ask you this: forgetting what we think is going to happen, forgetting all of these legal arguments and potential appeals, let me ask you to bottom line it for us. And again, I'm going to go ahead and tell you, I think Alec Murdaugh, if he didn't do this, he knows who did, and lied about it at every step of the way, and that's on him. I do think the jury reached the correct verdict. Whether they got there the right way, again, we're discussing now. But let me ask you this. You mentioned it the last time we talked about what justice demands. Putting aside the legal arguments, what do you think should happen here?
Oh, that's such a hard question to answer, because it's always it depends when you ask a lawyer. I don't know that I think it would have been easier for the state as a whole, although it would have been extremely expensive and extremely time consuming to retry this case. But in a way, it could have possibly dealt with all the other appealable issues. Just because we deal with this issue doesn't mean that there might not be a new trial granted on one of the other, causes or issues that are up on appeal right now. So if we had just stopped and started over, I think it might have put a little bit more faith into the judicial system, because you have two different schools of thought right now. Some people are praising Justice Toll for saying he did it. They got the right verdict. I don't care how they got it. Let's just move on and put him away. And then you've got other people that are saying, wait, if this is now the standard that a clerk of court or an official of the court can have communications to this degree, and there's no remedy that's put in place for a defendant that, could be considered a victim of those actions, what standard does that set going forward? So there's no easy answer here, and it's certainly going to impact the justice system either way. I have no doubt that her intention is to clean this up and to make it nice and as perfectly wrapped as possible. But it's not an easy package to wrap. And I don't know that anyone is going to be completely satisfied with her ruling, no matter what the justification is or what comes out during the testimony.
Well, once again, Lauren, you cut through the noise, all of the chatter on social, all of the factionalism on this case. You do just an amazing job of bringing it down to the nuts and bolts. Thank you again, Lauren. Really looking forward to getting you on again the closer we get to the big hearing, as we analyze all of these issues at that hearing later this month. Lauren Taylor, everybody, from Lauren Taylor Law, thank you again for joining us.
Thank you. Well, have a good week.